Slezak, and coming to you live from the John Moriarty Studio, 231 West Bedford Road, Stockton, California. We're right off Pacific Avenue that the studio faces, but through a few walls. So here we are, enjoying life. And putting up the billboard, and that is the Saturday evening news, and with your host Tichard Slezak. And so we can just go right to start broadcast. Bam! Welcome, Facebook viewers. And we're going to get right to this evening's show. Our sponsors are Hotel Furniture Liquidators. Let me get the book out here. Wrong binder. We're in wrong binder. Here we go. Tender Donuts, 1304 East Hammer Lane. Hotel Furniture Liquidators, 1646 North Shaw Road, off East Fremont, just east of 99. Custom Plastics and Signs, 326 East Dr. Martin Luther King Boulevard, between San Joaquin and Sutter. On the road for you in the 209-922-1879, Millennium Computer Repair. Again, that's 209-922-1879. Habitat for Humanity Restore at 4933 West Lane. The Miracle Mile Bookstore, 2210 Pacific Avenue, and Doors Book Recyclery, 2310 Pacific Avenue. And Leaders T-shirt and Printing, 500 East Lodi Avenue at Garfield in Lodi. All right. And we're going to go right into our episode 21. Today is... we put in the day backwards here. It's October 5th, 2019. And Saturday evening news. Got to put up another billboard for the reporting. And we have, oh my, 8:34 p.m. We're starting in 3, 2, 1. Good evening, ladies and gentlemen. This is the Saturday Evening News coming to you over thevoiceofstockton.org, also over YouTube and Facebook as I speak. And we're coming to you from the John Moriarty Studio. It is episode 21 of the Mueller Report, and we're diving right on in. All right. Continuing to march over here to the big desk. I've got water and coffee handy. Oh my, hope you're okay. Here we go. We got this fine microphone, and I'm gonna just set it down here and scroll down the page, hopefully hit it right off the bat. It's about halfway, and where are we at? That's page 21. Page 15. And scroll up some. 12. Alrighty. About to pour right on into the Mueller Report. We're resuming in volume 2 on page 7. All right. And whoop, get the paper square. 8:34 p.m. And we're at page 7. And we did not make overarching factual issues. We did not make a traditional prosecution decision about these facts, but the evidence we obtained supports several general statements about the president's conduct. Several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First, the investigation concerned the president and some of his actions, such as firing the FBI director, involved facially FACIALLY lawful acts within his Article 2 authority, which raises constitutional issues discussed below. At the same time, the president's position as the head of the executive branch provided him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses, all of which is relevant to a potential obstruction of justice analysis. Second, unlike cases in which the subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime related to Russian election interference, although the obstruction statutes that do not require proof of such a crime. The absence of that evidence affects the analysis of the president's intent and requires consideration of either possible motives for his conduct. Third, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, took place in public view. That circumstance is unusual, but no principle of law excludes public acts from the reach of the obstruction laws. If the likely effect of public acts is to influence witnesses or alter their testimony, the harm to the justice system's integrity is the same. A key point here, we're on page 7, and yes, no principle of law excludes public acts from the reach of the obstruction laws. Okay. Although the series of events we investigated involved discrete acts, the overall pattern of the President's conduct towards the investigations can shed light on the nature of the President's acts and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into two phases, reflecting a possible shift in the President's motives. The first phase covered the period from the President's first interactions with Comey through the President's firing of Comey. During that time, the President had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the President became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the President engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the President's motives during each phase would be informed by the totality of the evidence. Alrighty. Paragraph 2 on Comey, which would have been January 17 to firing, and phase 1 and phase 2 post Comey firing as one of 10 obstruction OJ of justice actions. So the Comey firing was impeachable. That could be one of the charges. Right there. Case. Statutory and constitutional defenses. The President's counsel raised statutory and constitutional defenses to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defenses provided a basis to investigate the facts. Statutory defenses consistent with precedent and the Department of Justice's general approach to interpreting obstruction statutes, we concluded that several statutes could apply here. 18 U.S. Code, sections 1503, 1505, 1512B3, and 1512E2. Section 1512E2 is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs the integrity or availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement of information related to a federal crime. Let me do an engineering correction and check here. Alrighty. And take that down to 0. And let's, okay, things are fine there. So we got the feeds are fine. Got my second pen. Got 8:48 p.m. here at the Voice of Stockton. We're on page 8 of the volume 2 of the Mueller Report. Constitutional defenses. As for constitutional defenses arising from the president's status as the head of the executive branch, we recognize that the Department of Justice and the courts have not definitively resolved these issues. We therefore examine those issues through the framework established by the Supreme Court precedent governing separation of powers issues. The Department of Justice and the President's personal counsel. I'm looking at where the power cords are coming in. I'm right in front of this sign to begin with, and I'm going to angle that camera over here just a hair. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the president's ability to fulfill his constitutional mission. The term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A preclusion of corrupt official actions does not diminish the president's ability to exercise Article 2 powers. For example, the proper supervision of criminal law does not demand freedom for the president to act with a corrupt intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers rather than hinders the impartial and even-handed administration of the law. It also aligns with the president's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the president's conduct is justified, inquiries to determine whether the president acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office accords with our constitutional system of checks and balances and the principles that no person is above the law. Conclusion: because we determined not to make a traditional prosecutorial judgment, We did not draw ultimate conclusion about the President's conduct. The evidence we obtained about the President's actions and intent presents difficult issues that would need to be resolved if we were making a tradition prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude the President committed a crime, it also does not exonerate him. And page 8. No exoneration of Prez conduct. Onwards to page 9, background, legal, and evidentiary principles. A. Legal framework of obstruction of justice. We have 853 here at the Voice of Stockton. This is the Mueller Report, episode 21. We're on page 9 now of volume 2. The May 17, 2017 appointment order and the special counsel regulations provide this office with jurisdiction to investigate, quote, federal crimes committed in the course of and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, obstruction of evidence, destruction of evidence, and intimidation of witnesses. 28 CFR, Code of Federal Regulations 600.4. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of obstruction offenses in mind. On the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under principles of federal prosecution. See Justice Manual 9-27. And here we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report addressing constitutional defenses that the President's counsel have raised. 3 basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding, and 3, a corrupt intent. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering, that's 18 U.S. Code 1512B, and describe the requirements for attempted offenses and endeavors to obstruct justice. Obstructive acts. Obstruction of justice law, quote, reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered regardless of the means employed. Unquote. That comes from U.S. versus Silverman, an 11th Circuit 1984 decision, interpreting 18 U.S. Code 1503. An effort to influence, quote unquote, a proceeding can qualify as an endeavor to obstruct justice even if the effort was, quote, subtle or circuitous, unquote, and, quote, however cleverly or with whatever cloaking of purpose, unquote, it was made. And that was in U.S. versus Roe, 4th Circuit, 1975 decision. And there's also U.S. versus Quattroni, 2nd Circuit, 2006 decision. The verbs obstruct or impede are broad and can refer to anything that blocks, makes difficult, or hinders. An improper motive can render an actor's conduct criminal, even when the conduct would otherwise be lawful and within the actor's authority. And that comes from U.S. versus Cueto, 7th Circuit, 1998 ruling, affirming obstruction conviction of criminal defense attorney for litigation-related conduct. And U.S. versus Sintolo, and that was 1st Circuit, 1987 decision, quote, any act by any party, whether lawful or unlawful on its face, may abridge Statute 1503 if performed with a corrupt motive. Continuing on page 9, nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus or connection to an official proceeding. That's in 1503 section. The nexus must be pending judicial or grand jury proceedings. That comes from U.S. versus Aguilar. And that was a 1995 decision. And we're on page 10 now. Page 9. Legal opinions. Rulings and statutes. We have 9 p.m. This is the voice of Stockton.org. I am Tichard Slezak. We're coming to you live over YouTube and Facebook as well from the John Moriarty studio, right off Pacific Avenue at Bedford Road in Stockton, California, and statutes on obstruction of justice, double OJ. Okay. Under both statutes, the government must demonstrate, quote, a relationship in time, causation, or logic, unquote, between the obstructive act and the proceeding or inquiry to be obstructed. Oh, that was Arthur Anderson, LLP versus U.S., a 2005 decision. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. Although a proceeding need not already be in progress to trigger liability under Section 1512C, a nexus to a contemplated proceeding still must be shown. And that comes from U.S. versus Young, 4th Circuit, 2019, and U.S. versus Petruk, 8th Circuit, 2015, U.S. versus Phillips, 10th Circuit, 2009, U.S. versus Reich, 2nd Circuit 2007. The nexus requirements narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law prescribes. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice, such as the statute excludes defendants who have an evil purpose but use means that would only unnaturally or improbably be successful. The endeavor must have the natural and probable effect of interfering with the due administration of justice. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. A defendant need not directly impede the proceeding. Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceedings if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly or with improper motive. And that was U.S. versus Richardson, 5th Circuit, 2012, U.S. versus Gordon, 10th Circuit, 2013. To enact corruptly means to act with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceeding the term corruptly means acting with an improper purpose personally or by influencing others. Interpreting corruptly to mean wrongful, immoral, depraved, or evil, and holding the acting knowingly corruptly. It requires consciousness of wrongdoing. The requisite showing is made when a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. And that was in Ballantyne's Law Dictionary, edited 1969, U.S. versus Pasha, that's D.C. Circuit 2015, Aguilar and Scalia, concurring in part and dissenting in part, characterizing this definition as the long-standing and well-accepted meaning of corruptly. Witness tampering, a more specific provision in Section 1512, prohibits tampering with a witness, making it a crime to knowingly use intimidation or corruptly persuade another person or engage in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of any person in an official proceeding, or to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a federal offense. And page 10 is more of the same. Legal opinions, that is rulings and statutes on obstruction of justice. Nexus. Corruptly. To establish corrupt persuasion, it is sufficient that the defendant ask a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. Several cases are listed here as to support that. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, or coach or remind witnesses by planting misleading facts. Corrupt persuasion is shown where a defendant tells a potential witness a false story as if the story were true, intending that the witness believe the story and testify to it. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. Corrupt persuasion also can be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with law enforcement, telling a secretary not to say anything to the FBI and she would not be bothered. As an example, when the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a proceeding inquiry articulated in Aguilar, that an individual have knowledge that his actions are likely to affect judicial proceedings, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. And continuing, acting knowingly, corruptly requires proof that the individual was conscious of wrongdoing. Declining to explore the outer limits of this element, but indicating that an instruction was infirm where it permitted conviction even if the defendant honestly and sincerely believed that the conduct was lawful. It is an affirmative defense that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. Or on page 11, volume 2 of the Mueller Report. It is 9:10 p.m. I am Tichard Slezak. This is the voice of Stockton.org. And let me take a little water break. I don't know if that fan's really helping. It seems to be pumping a lot of warm air. So I'm just going to turn it off for a while. And, my. Let me get a swig of water. Got 9/11 here at the Voice of Stockton. Yeah. And what the heck? Good. Attempts and endeavors. Section 1512 C2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. Let me, where's a headset to get, ooh. Alrighty. Yeah, this works pretty good. The act must be substantial in that it was strongly corroborative of the defendant's criminal purpose. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. Onward to page 12. Yeah. Page 12. No, page 11. Yeah, we have add attempts and endeavors. Continuing on page 12. The Omnibus Clause of 18 U.S. Code 1503 prohibits an endeavor to obstruct justice which sweeps more broadly than Section 1512's attempt provision. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice, the prosecution, and need not prove that the due administration of justice was actually obstructed or impeded. And Section B, investigative and evidentiary considerations. After the appointment of the special counsel, this office obtained evidence about the following events relating to potential issues of obstruction of justice involving the President. A. The President's January 27, 2017 dinner with former FBI Director James Comey, in which the President reportedly asked for Comey's loyalty 1 day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. The President's February 14, 2017 meeting with Comey, in which the President reportedly asked Comey not to pursue an investigation of Flynn. C. The President's private request to Comey to make public the fact that the President was not the subject of an FBI investigation and to lift what the President regarded as a cloud. D. The President's outreach to the Director of National Intelligence and the directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. E. The President's stated rationales for terminating Comey on May 9, 2017, including statements that could reasonably be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination, and F. The President's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and omitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Okay, page 12 is Comey firing Comey firing as obstruction of justice. Taking into account that information and our analysis of applicable statutory and constitutional principles, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the president. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested that the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information, and we interviewed other witnesses who had pertinent knowledge, obtain documents on a voluntary basis when possible, and used legal process where appropriate. Those investigative steps allowed us to gather a substantial amount of evidence. And so they Comey firing and Mueller gathers evidence from White House and administration. We also sought, now we're on page 13, we also sought a voluntary interview with the president. After more than a year of discussion, the president declined to be interviewed. Then grand jury, 2 lines blacked out. During the course of our discussions, the president did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believe that we had the authority and legal justification to issue a grand jury subpoena to obtain the president's testimony, we chose not to do so. Wow. And this is on page 13. Special counsel had authority to issue a grand jury subpoena, SUBPOENA, subpoena the president to testify? Ooh, they chose not to. We made the decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that based on the significant body of evidence we had already obtained of the President's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the President's testimony. The office's decision-making process on this issue is described in more detail in Appendix C, and note that precedes the President's written responses. We have 923 here at the Voice of Stockton. This is the Mueller Report. We're on page 13 in Volume 2. And let me do an electronics check here of the feed of the video. You need to make sure about that. Don't want you to be stuck high and dry. Yep, we're good. Alrighty-us. Back at it. In assessing evidence we obtained, we relied on principles that apply in any investigation. The issue of criminal intent is often inferred from... Therefore, mens rea elements such as knowledge or intent may be proved by circumstantial evidence. The government's case rested on circumstantial evidence, but the mens rea elements of knowledge and intent can often be proved through circumstantial evidence and the reasonable inferences drawn therefrom. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment and therefore decline to testify. Accordingly, determinations on intent are frequently reached without the opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule, relying on significant circumstantial evidence that the defendant was conscious of her wrongdoing in an obstruction case, because of evidence of intent will almost always be circumstantial. A defendant may be found culpable where the reasonable and foreseeable consequences of her acts are the obstruction of justice. Circumstantial evidence that illustrates intent may include a pattern of potentially obstructive acts. Evidence of a crime, wrong, or other act may be admissible to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Credibility judgments may also be made based on objective facts and circumstantial evidence. Standard jury instructions highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had a reason not to tell the truth, whether the witness had a good memory, whether the witness had the opportunity to observe the events about which he testified, whether the witness' testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. In addition to those general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of the facts. For example, contemporaneous written notes can provide strong corroborating evidence. The fact that a statement appeared in a contemporaneously recorded report would tend strongly to corroborate the investigator's version of the interview. Similarly, a witness's recitation of his account before he had any motive to fabricate also supports the witness's credibility. A consistent statement that predates the motive is a square rebuttal of the charge that the testimony was contrived as a consequence of that motive. Finally, a witness's false description of an encounter can imply consciousness of wrongdoing, noting that well-settled principle that false exculpatory statements are evidence, often strong evidence of guilt. We applied those settled legal principles in evaluating the factual results of our investigation. Okay, and on to page 14. Settled legal principles applied to Trump violations have continued to occur. Yeah, reading this thing, it's just, wow, this is just the past few days. Wow. Continuing, that was page 14. Now on to 15. We have 929 here at the Voice of Stockton. Factual results of the obstruction investigation. This section of the report details the evidence we obtained. We first provide an overview of how Russia became an issue in the 2016 presidential campaign and how candidate Trump responded. We then turn to the key events that we investigated, the president's conduct concerning the FBI investigation of Michael Flynn, the president's reaction to public confirmation of the FBI's Russia investigation, events leading up to and surrounding the termination of FBI Director Comey, efforts to terminate the special counsel, efforts to curtail the scope of the special counsel's investigation, efforts to prevent disclosure of information about the June 9th, 2016 Trump Tower meeting between Russians and senior campaign officials, efforts to have the Attorney General unrecuse and conduct towards McGahn, Cohen, and other witnesses. Oh my. Here on page 15 are 7+ events, criminal and (2016, 2017) and by Trump. We summarize the evidence we found and then analyze it by reference to 3 statutory obstruction of justice elements: obstructive act, nexus to a proceeding, and intent. We focus on elements because by regulation the special counsel has jurisdiction to investigate federal crimes committed in the course of and with intent to interfere with the special counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Consistent with our jurisdiction to investigate federal obstruction crimes, we gathered evidence that is relevant to the elements of those crimes and analyzed them within elements framework, while refraining from reaching ultimate conclusions about whether crimes were committed for the reasons explained above. This section also does not address legal and constitutional defenses raised by counsel for the president. The campaign's response to reports about Russia's support for Trump. During the 2016 campaign, the media raised questions about a possible connection between the Trump campaign and Russia. And the footnote states this section summarizes and cites various news stories, not for the truth of the information contained in the stories, but rather to place candidate Trump's response to those stories in context. Volume 1 of this report analyzes the underlying facts of several relevant events that were reported on by the media during the campaign. Continuing, the questions intensified after WikiLeaks released politically damaging Democratic Party emails that were reported to have been hacked by Russia. Trump responded to questions about possible connections to Russia by denying any business involvement in Russia, even though the Trump Organization had pursued a business project in Russia as late as June 2016. Trump also expressed skepticism that Russia had hacked the emails at the same time as he and other campaign advisors privately sought information. Then a few words are harm to ongoing matter. Continuing, about any further planned WikiLeaks releases. After the election, when questions persisted about possible links between Russia and the Trump campaign, the president-elect continued to deny any connections to Russia and privately expressed concerns that reports of Russian election interference might lead the public to question the legitimacy of his election. Okay, that was footnote 8. While the investigation identified numerous links between individuals with ties to the Russian government and individuals associated with the Trump campaign, the evidence was not sufficient to charge that any member of the Trump campaign conspired or coordinated with representatives of the Russian government to interfere in the 2016 election. Yeah, we have 9:35 here at the Voice of Stockton. Right to end of page 15. All right. And with that completes our reading. Let me check where we're at on the audition. And that's our recording apparatus to see if we're, oh yeah, we're right up there. And with that, this has been the Saturday Evening News, episode 21 of the Mueller Report, volume 2. We just covered pages 7 through 15 on the obstruction of justice, how it's definitely defined, and boy, yep, El Presidente numerous times. We've been seeing a lot of that lately. Okay, let me, wrong mouse. We have a number of mice here, the electronic variety. With that. Alrighty, thanks for listening in. This has been episode 21 of the Mueller Report. And we're continuing with live radio, Facebook, and YouTube. And thanks for watching and listening in. I'm going to bid adieu to YouTube. Have a good evening. Thanks